Good afternoon, ladies and gentlemen. Welcome back to Bexar County Court at Law Number 6 in the Bexar County Veterans Treatment Court. I'm Judge Wayne Christian. Today is plea day. On our docket for the day, we have one motion to revoke community supervision, cause number 651887, State of Texas versus Jonathan Sanchez, represented by Cesar Montalvo. We have one Bexar County Veterans Treatment Court, track 1 pretrial diversion plea and agreement. Cause number 657287, State of Texas versus Moises Trevino, represented by Mr. William Salazar. We have 1, 2, 3, 4, 5, 6 conventional pleas. Cause number 651285, State of Texas versus Ricardo Rivera, represented by Ms. Gail Calderola. Cause 674777, State of Texas versus Jeffrey Burnett, represented by Mr. Leslie Herbst. Cause
Judge,
yes.
I'm sorry to interrupt you. We don't have Mike.
We just lost Mike?
Yes.
Oh, no.
Well, we can go through the docket without Mike. It's just when we start actually doing pleas and MTR. Cause number 655959, State of Texas versus Michaela Grimaldo, represented by Mr. Roland Garcia. Cause number 643249, State of Texas versus Larry Peterson, represented by Mr. Ernest Acevedo. And cause number 672944, State of Texas versus Christopher Symes, represented by Mr. Brian O'Donnell. And cause number 654902, State of Texas versus Nancy Moir, represented by Mr. Tony Hernandez. And have we gotten Michael back yet? Do we know?
No, Your Honor, I have texted him to come back in. I don't know whether he was having issues prior to this, but he had resolved them. So I just texted him.
Well, let's take a break and let's see where our court reporter went.
Okay.
May I approach, Your Honor? It's Brian O'Donnell.
Sure, Brian. Who's got?
Your Honor, I have my client on my speakerphone, Mr. Christopher Symes. We are ready for a plea. However, he's on his phone and his Zoom application won't populate. I don't believe we'll be able to go forward today, Judge.
Okay. Well, I may have to put it off till next week unless you've got a way to fix that.
Well, I was wondering if we could put it off for a week, and my client, he could come to my office in the basement of the courthouse. We could do the plea there, Judge.
Sure. How about next Thursday work for y'all?
Yes, Your Honor. If it's in the afternoon like this, it will be just fine.
It'll be 2 o'clock on Thursday, the
The 10th.
10th. Exactly.
Very well.
All right.
May we be excused, Your Honor?
You bet. Thanks, Brian.
Thank you, Your Honor.
Your Honor, Mr. Acevedo running late, and I'm going to try to get a hold of Mike right now. Hold on. Mr. Acevedo is not going to be late.
Putting his file back in our file. Okay, we're good. Ernie, we lost Mike, so we're waiting to get our court reporter back.
Okay, sorry about being late, Judge.
Oh, no, you're not late. You're right on time. Perfect.
I blame the weather,
Fair enough.
as far as anyone knows.
He is trying to get back in, Your Honor, but he's having a little issue. He had an issue when he came in as well. He couldn't get sound. So he's trying.
Okay, we'll wait. Do we have a backup court reporter in mind?
No, but I'll ask Mike if he will get someone, right?
We can't take too long or Miss Calderola will miss happy hour and then she'll be mad at me.
I have no heat here, Judge. The power's off.
Your Honor, I'm just going to give him another minute, and if not, then I'm going to try to get a hold of Yvonne and see. I do have her cell.
Are we able to waive a record, Judge? I mean, if we
He's
would waive a
coming
record-
in. He's coming in.
Not to my knowledge.
I say we try it. Who's going to appeal it?
He's coming in. He's coming in.
I agree.
I'm back.
I can promise you
Right.
I'm not.
Can you hear us?
Yes, crystal clear.
Go now.
All right, Mike, are we good to go?
Good to go, Judge.
All right, back on the record. The first case we've got is a motion to revoke community supervision. Clause number 651887, State of Texas versus Jonathan Sanchez, represented by Mr. Cesar Montalvo. Mr. Montalvo, are you ready to proceed?
Yes, Your Honor.
And representing the state is Assistant Criminal District Attorney Eddie Villarreal, and representing the Bexar County CSCD is Ms. Susan Gross, who I will swear in at this time. Ms. Gross, please raise your right hand. You swear the testimony you are about to give to be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir, I do.
Thank you. The first document I'm looking at is entitled Defendant's Consent to Motion to Revoke Hearing by Video Conference that purports to have both Mr. Sanchez and Mr. Montalvo's signatures on it. In fact, Mr. Sanchez, is this your signature on this document, sir?
Yes, sir.
Thank you. Mr. Montalvo, as attorney for Mr. Sanchez, is this also your signature on this document?
Yes, sir.
Thank you. The next document I have is entitled Trial Court Certification of Defendant's Right of Appeal, which should be marked is a revocation of the defendant's community supervision, and the defendant has a right to appeal the court's actions, revoking the community supervision, but not the underlying conviction. My understanding was originally this was mismarked and that Ms. Benavides is going to administratively change it to the correct one. Is that correct, Ms. Benavides?
Yes, Your Honor.
Okay. And Mr. Sanchez, is this your signature on this document also, sir?
Yes, sir.
Thank you. And Mr. Montalvo, as attorney for Mr. Sanchez, is this also your signature on this document?
Yes, Your Honor.
Thank you. Mr. Montalvo, my understanding is that this is an uncontested motion to revoke community supervision. Is that correct?
Your Honor, we would plead true to all conditions except 20 failed to obtain the SCRAM device.
Okay, and that's not a problem. The ultimate issue in my question is whether you wanted a contested motion to revoke, or you can plead true or not true to any of these, and I'm just going to make a decision ultimately on them after you present whatever evidence you'd like to present. Is that
That's
fair?
correct. Yes, Your Honor. We'll proceed
Okay,
uncontested.
so the court accepts the plea of true with an explanation to all conditions except for number 20, and that is not true with an explanation. Would that be accurate, Mr. Montalvo?
Yes, Your Honor.
Fair enough. Ms. Gross, would you please advise the court and the parties of the status of Mr. Sanchez's probation?
Yes, Your Honor. Mr. Sanchez has been reporting as directed. His case is paid in full. We last saw him on January 20th, 2022. He has completed all 24 hours of his community service, DWI education, victim impact panel, and the CATSNP program. He was ordered to take the CATS intensive outpatient program, and he was exited from that for non-attendance per the instructor on September 15th of 2021. He's had 7 negative drug tests, 1 diluted drug test, and 4 positives. 3 were positive for marijuana, and that was back in June and July of 2021. And he had 1 positive UA for alcohol. And then he has had 2 positive specimens on the Smart Start mobile device, where he is currently blowing 4 times per day. He has had 8 skips between November 20th and December 30th, and 2 high bracs of 0.035 on January 9th, 2022. And then he also had a female unknown blow into the device to clear it out. He went into lockout on December 18th, 2021, and was in lockout for about a day. As a result of the skip tests and the violations, a violation report was submitted to court on January the 7th. And the court graciously, rather than filing a motion to revoke, agreed to amend his conditions and ordered that conditions be amended and that the defendant obtain a scram device within 10 days. To this date, the defendant has failed to obtain that device and continues to utilize the Smart Start mobile device. And he has had a skip test as recently as yesterday. This is his 5th violation report, 3rd motion to revoke. He does not have a criminal history, and his probation officer is requesting revocation.
Mr. Montalvo, over to you.
Yes, Your Honor. Mr. Sanchez is set to expire here this next month. As to the lockout, Mr. Sanchez, this was on a Saturday. There was an issue with the Smart Start, which he reported to Smart Start and to his PO. I believe his name was Daniel Ovalle. And this was on a Saturday, and that had to be recalibrated. This was through no fault of his own. Last time we were here, the orders were amended that he have the Smart Start device for 30 days. I don't see that no skips were ordered, but indeed he would have been ordered on December 4th to have that removed. These violations after December 4th wouldn't be valid. They wouldn't be violations at the time. And then finally, as far as the scram device, my client avers that he was never notified about having to get a scram device. Of course, he can't be held, to have that violation unless he had notice.
My understanding through the probation department was he contacted you because he didn't want the scram device. And at some point you filed a motion, we were going to have a hearing about that. Was that not true?
Yes, Your Honor. We filed that because we wanted to get that removed. It was supposed to get removed on December 4th, 2021.
Well, why would he contact you about removing the scram device if he didn't know he was supposed to get a scram device?
No, he contacted me on removing the Smart Start mobile.
Okay, but and I apologize. Maybe I was confused by what your statement was, but Mr. Sanchez did receive notice from the probation department that at some point he was supposed to acquire a scram cam ankle bracelet. Is that true?
I believe he was told on his last meeting, which was January 20th. And at the time he had spoken with his PO, he said that he would hold off on having Mr. Sanchez get the scram device until we had a meeting or until we were heard on this motion.
All right. Well, probation officer doesn't have the authority to do that. Only a judge has the authority to do that. And you're well aware of that, are you not?
Indeed, Your Honor.
Judge?
Yeah, go ahead, Sue.
I'm reading the officer's notes right here from his office visit on the 20th. And the probation officer discussed the scram situation with the defendant and advised him that he needed to sign the alternate amended conditions and get the device. And the defendant refused to sign the conditions. I've also spoken to the officer. The defendant refused to sign the conditions and said that he is talking to his lawyer about not having to get the scram device. And when we were in court the last time, and he was extended on the Smart Start mobile device, I believe it was stated that you would consider removing him after 30 days, providing there were no skips and no high bracs. There was not a guarantee given there. You would consider it.
Hey, Mr. Sanchez, do me a favor and lower your camera just a little. I'm kind of seeing you from eye level up. That's great, sir. Thank you. Okay, Mr. Montalvo, anything else you want to bring up at this time?
Your Honor, well, at this time, I would simply ask that he be continued or that he simply be ordered to take that the order be amended to add Scram. He's on his last month here. He's had a tough go of it, but he has demonstrated that he's willing to do the work here. That he does suffer from anxiety, and he's doing his best in this case.
Can you comment on the allegation, which is number 15, looks like 15 ABC, I'm going to call C for Charlie for record purposes, wherein it is alleged that an unidentified female in a Spurs cap blew into the Smart Start mobile device to submit a clean test window for the defendant?
Your Honor, I really could not. I would have to defer to my client on that.
Okay. Mr. Sanchez, do you have anything to say about that?
I really can't understand you.
And hang on, sir. I'm having a hard time hearing you. Go say that all again, please.
Maybe get closer to the camera and the microphone.
Can't hear the conversations that are going on.
Get closer to the microphone and the camera because your speech is coming through garbled.
No, I know. That's what I'm saying. Like I can't. So is y'all speeches. I can't hear y'all properly. Like it's breaking up.
Okay, well, I hear you fine now. Can you hear me?
Yes. Now I
All
can.
right, sir. My question is, what is your side of the story on that you apparently let a female blow into your Smart Start mobile device?
That was 100% my fault. I had recently I had COVID like literally pretty much all month last month. So I recently got told that I don't get no COVID relief pay. So I just got upset and I drank a beer and then I was taking cough medicine as well. And when I blew in it, it just a blue violation. But I didn't feel like I had any like I was drunk or anything like that. So I thought it was just messing up. So then I told my girlfriend to blow in it and then it passed and that's what happened.
Okay. Ms. Gross, tell me again, and I apologize, I missed that. What specific date that Mr. Sanchez was advised by his probation officer that he needed to get a Smart Start mobile device within 10 days?
It looks like it was on January 20th at 10:31 in the morning.
Mr. Sanchez, do you remember that conversation with your probation officer where she told
Yes.
you that the judge, that would be me, had ordered you to get a Scram ankle bracelet,
Yes, sir.
alcohol
And-
detection device?
Yes,
Go ahead.
sir. And what my attorney stated is exactly what he told me. He was like, okay, well, I'm gonna put a hold off on it until you talk to Judge Christian, because I told him we were gonna have this meeting. It wasn't supposed to be an MTR meeting, so I kind of screwed myself on that part. It was just supposed to be a meeting to where you can hear me to get my start taken away.
Okay, so what you're telling me is you're
And then
go ahead, sir. Don't let me interrupt you. Go ahead.
If he would have told me, I'm sorry. If he would have told me to it was supposed to get done, I would have went and did it. I ain't trying to not get something done that you say. But what he stated to me was, okay, well, let's see what Judge Christian says, and then we'll go from there. So I just went with what my probation officer had stated to me. And that's what I had told my attorney as well.
And Judge, if I may,
Sure.
I talked to the officer, Mr. Ovalle, and he said that he advised the defendant to sign the conditions and he refused. And that's when it was decided that it would come back to you to be handled and the MTR was filed.
Okay, well, Mr. Sanchez, at some point in there, you were told that I had ordered you to get a Smart Start, and a Scram Cam ankle bracelet. And you're telling me your conversation with your probation officer was she told you that she would not continue to make you get one until you'd had time to have your attorney contact me. Is that correct?
Until we had our meeting, because I told him how I was talking to you already to get the Smart Start device already taken care of. Like it was, you were going to have not an MTR meeting, but like a meeting to just get it dismissed. And then when he said that, he was like, okay, well then just let me know how it goes out. And then that's what we did. I don't even have a thing in my email to where I have to sign something for me to get the Scram device.
And my client might be referring to a motion to remove the Smart Start device.
Well, I think that's what we were going. Oh, Well, today, before this MTR was filed, we were going to have a hearing today about the Scram device, right?
Smart Start, removal of Smart Start.
But I never told you, Mr. Montalvo, and I certainly never told Mr. Sanchez that I was going to hold off my order for him to acquire the Scram device and wait till the results of the hearing. So
Sure.
I never told you that,
Of
did
course.
I? No.
No, Your Honor.
All right, understand. And Susan, did you say this is the third MTR on Mr. Sanchez?
Yes, he's had a total of 5 violation reports. 2 of those violation reports were handled between you, the officer, and the defendant. You took action, but you didn't issue a warrant on a motion to revoke and bring them to court. We have filed a total of 3 violation reports that have resulted in motions to revoke, which have landed us here on Zoom MTRs. So 5 violation reports, 3 MTRs.
How nice I've been. Goodness gracious. I'm going to get a bad reputation. All right, Mr. Sanchez, are you working? Are you going to school? Got any children?
Yes,
What are you
sir.
doing?
I'm a dental technician and I'm a full-time father.
You're a dental technician. Is that what you said?
Yes, sir.
And you have a job as a dental technician?
Yes, sir.
Do you have any children, sir?
Yes, sir. I have 2. I'm
How
a
old?
full-time father.
How old are
I
they?
have a 4-year-old and a 9-year-old.
And you live with them?
Yes, sir.
Okay, I got it. State, what's your recommendation, please?
Your Honor, the state recommends revocation.
The defense opposes, I think, given these circumstances, he's set to expire in a month, and any revocation would subject him to obviously the underlying jail time and any of the terms.
Susan, do you have the original fine amount on Mr. Sanchez's case available?
Yes, Your Honor. His original fine was $300.
Wow. Mr. Sanchez, in clause 651-887, the court accepts your plea of true with an explanation to all conditions except for number 20, and not true with an explanation about failure to obtain the SRAM device within 10 days as directed by the supervision officer. I grant the state's motion to revoke your probation. I sentence you to 90 days in the Bexar County Jail, assess a $300 fine plus court costs, credit for time served, time and money to run concurrent. You're to report to the Bexar County Jail on Monday, the 7th of February 2022 to serve your sentence. I gave you credit for another 90 days for what you've already done on this case. Good. Unfortunately, it was outweighed by what you haven't done on this case and what you've done bad. So there it is. Anything further from the state of the defense on Mr. Sanchez?
Nothing from the state, Judge.
No, Your Honor.
Good luck, Mr. Sanchez. Thank you, Mr. Monsalvo. Okay. Adding order on, please. State of Texas versus Moises Trevino, represented by Mr. William Salazar, 657-287. Are you ready to proceed, Mr. Salazar?
Yes, good afternoon, Your Honor.
Thank you. Cause number 651-285, State of Texas versus Richard J. Rivera, represented by Ms. Gail Calderola. Ms. Calderola, are you ready to proceed?
Yes, Your Honor.
Thank you. Cause number 674-777, State of Texas versus Jeffrey L. Burnett, represented by Mr. Leslie Herbst. Mr. Herbst, are you ready to proceed?
Yes, Your Honor, we're ready to proceed.
Thank you. And cause number 654-902, State of Texas versus Nancy Moore, represented by Mr. Tony Hernandez. Mr. Hernandez, are you ready to proceed?
We're ready, Your Honor.
And cause 643-249, State of Texas versus Larry J. Peterson, represented by Mr. Ernest Acevedo. Mr. Acevedo, are you ready to proceed?
We are ready to proceed.
Thank you. The first document I have on all these cases is entitled Defendant's Consent to Plea by Video Conference. That purports to have both the defendant and his attorney's signature on it. In fact, Mr. Trevino, in clause 657-287, is this your signature on this document, sir?
Mr. Trevino, if you could,
Document.
I'll say
I don't
again.
believe you're sharing the screen, Judge.
I can see Mr. Trevino. Mr. Trevino, can you hear me, sir?
Yes, sir.
Is this your signature on this document, sir?
I don't,
Let's try again. Is this your signature on the document titled Defendant's Consent to Plea by Video Conference?
Mr. Trevino, you've muted yourself again. I apologize, Judge.
Oh, no, it's not a problem.
oh, sorry. I'm trying to look for the,
I had to do that too early on. It took me a while to figure it out.
Your
Mr.
Honor,
Trevino-
he's
It's
looking
not
for the
on the screen.
paperwork. It's not up in the screen. You're not sharing that. So he's saying he doesn't see it. So he can't say.
Everybody stop talking, please. Mr. Trevino, at some point when you were preparing the paperwork, there was a document that was titled Defendant's Consent to Plea by Video Conference. And all that means is that both you and your attorney agree to be on video doing our plea instead of in person. Do you remember signing
yes,
that?
Your Honor, I've signed everything.
All right, great. Thank you, sir. And Mr. Salazar, this is also your signature on this document.
Yes, Your Honor.
Thank you. Mr. Rivera, and cross 651285, is this your signature on this document, sir?
Yes, sir, it is.
Thank you. And Ms. Calderola, as attorney for Mr. Rivera, is this your signature on this document?
It is, Your Honor.
Thank you. Mr. Burnett, and clause 674777, is this your signature on this document, sir?
Yes, sir.
Thank you. And Mr. Herbst, as attorney for Mr. Burnett, is this also your signature on this document?
Yes, it is, Your Honor.
Thank you. Mr. Grimaldo, or excuse me, Miss Grimaldo, in clause 655959, is this your signature on this document, ma'am?
Yes, it is.
Thank you. And Mr. Garcia, as attorney for Miss Grimaldo, is this also your signature?
Yes, Your Honor.
Thank you. Mr. or Miss Moore, in clause 654902, is this your signature on this document, ma'am?
Yes, sir.
Thank you. And Mr. Hernandez, as attorney for Miss Moore, is this also your signature on this document?
Yes, Your Honor.
Thank you. Mr. Peterson, in clause 643249, is this your signature on this document, sir?
Yes, sir.
And Mr. Acevedo, as attorney for Mr. Peterson, is this also your signature on this document?
Yes, sir.
Thank you. The next document I have is entitled Defendant's Waiver of Constitutional Rights and Court's Admonitions. It purports to have your signatures on the back, effectively waiving certain constitutional rights you must waive in order to enter a plea before this court. In fact, Mr. Trevino, is this your signature on this document also, sir?
Again, I'm not seeing any documents, but I'm assuming so, sir.
Okay, thank you, sir. And Mr. Rivera, in clause 651285, is this your signature on this document?
Yes, Your Honor.
Thank you. And Mr. Burnett, in clause 674777, is this your signature on this document?
Yes, sir.
Thank you. And Ms. Grimaldo, in clause 655959, is this your signature on this document?
Yes, sir.
Thank you. Ms. Moore, in clause 654902, is this your signature on this document?
Yes, sir.
Thank you. And Mr. Peterson, in clause 643249, is this your signature on this document?
Yes, sir.
Thank you. Each of you, by signing this document, are you telling me that you've had enough time to either read this document or have it read to you in its entirety? If you had any questions about what was on this document, those questions were answered to your satisfaction by your attorneys, so that in signing this document, you're telling me that you agree with and understand everything on this document. Is that correct, Mr. Trevino?
Yes, Your Honor.
Thank you. Is that correct, Mr. Rivera?
Yes, sir.
Thank you. Is that correct, Mr. Burnett?
Yes, sir.
Thank you. Is that correct, Ms. Grimaldo?
Yes, sir.
Thank you. Is that correct, Ms. Moore?
Yes, sir.
Thank you. And is that correct, Mr. Peterson?
Yes, sir.
Mr. Salazar, the attorney for Mr. Trevino, have you had enough time to go over this case with him? And in your opinion, is he mentally competent?
He is, Your Honor. Yes, Your Honor.
Thank you. Same question for Ms. Calderola as attorney for Mr. Rivera.
Yes, Your Honor.
Thank you. Same question for Mr. Herbst as attorney for Mr. Burnett.
Yes, I believe he's competent, Your Honor.
Thank you. Same question for Mr. Garcia as attorney for Ms. Grimaldo.
Yes, Your Honor.
Thank you. Same question for Mr. Hernandez as attorney for Ms. Moore.
Yes, Your Honor.
And same question for Mr. Acevedo as attorney for Mr. Peterson.
Yes, sir.
Thank you. Mr. Trevino, are you a United States citizen, sir?
Yes, Your Honor.
Thank you. Mr. Rivera, same question.
Yes, Your Honor.
Thank you. Mr. Burnett, same question.
Yes, Your Honor.
Thank you. Ms. Grimaldo, same question.
Yes, sir.
Thank you. Ms. Moore, same question.
Yes, sir.
Thank you. And Mr. Peterson, same question.
Yes, sir.
Mr. Salazar, as attorney for Mr. Trevino, has the state fully complied with discovery for you on this case?
They have, Your Honor.
Thank you. Same question for Ms. Calderola, as attorney for Mr. Rivera.
Yes, Your Honor.
Thank you. Same question for Mr. Herbst, as attorney for Mr. Burnett.
Yes, Your Honor.
Thank you. Same question for Mr. Garcia, as attorney for Ms. Grimaldo.
Yes, Your Honor.
Thank you. Same question for Mr. Hernandez, as attorney for Ms. Moore.
Yes, Your Honor.
And same question for Mr. Acevedo, as attorney for Mr. Peterson.
Yes, sir.
Okay, give me 2 seconds to go grab my plea bargain sheet. Plea bargain sheet didn't print. Stand by. Let me print it out real quick. It's take forever, man. Okay, we're back on track. In cause number 657287, State of Texas versus Moises Trevino. To the charge of driving while intoxicated with a blood or breath alcohol content greater than 0.15. How do you plead, Mr. Trevino?
Guilty.
And state that is your intention. This is going to be a guilty on a DWI greater than 1.5. You're not waiving the enhancement.
No, Your Honor, the agreement was for 0.15.
Okay, Pat, paperwork needs to be administratively modified so that the defendant's waiver of constitutional rights and court's admonitions reflects driving while intoxicated greater than 0.15 and not just driving while intoxicated. Court accepts
sir.
guilty to the offense of driving while intoxicated with a blood or breath alcohol content of 0.15 or greater. State, is there an agreement in this case?
Yes, Judge, it's for 1 year VTC, $1,000 fine, a 48-hour, well, part of the treatment, 48 hours community service, which is to be probated for veteran service, AWI education, victim impact panel, Smart Start mobile for half the term, and VTC treatment and completion.
Okay, and bear with me, guys. I apologize. I neglected to pick up that this was a track 1 Bexar County Veterans Treatment Court plea and probation agreement. Mr. Trevino, on cause 657287, the court accepts your plea of guilty. I hold it in abeyance, place you on 1 year Bexar County Veterans Treatment Court, Track 1, pretrial diversion probation, assessing a $1,000 all-inclusive Veterans Treatment Court fee. 48 hours of community service, probating all that based on your military service. DWI education program, DWI victim impact panel, 6 months Smart Start mobile home interlock at 4 blows a day for half the term, which is 6 months. Outpatient drug treatment with either the Veterans Administration or another designated VTC provider. And there's no restitution on this case, correct, State? Good, none.
That's right, Judge. Yes.
Requiring your successful completion of the Veterans Treatment Court, issue judge's bond, defendant to be supervised by CSCD and VTC staff. At this time, Mr. Trevino, I'm looking at a document entitled Track 1, Pretrial Intervention, which is a contract by and between you and your attorney and the Bexar County Criminal District Attorney's Office. Said contract setting out all the terms and prerequisites of your successful completion of the Veterans Treatment Court. In fact, sir, is this your signature on this document?
Yes, sir.
And Mr. Salazar, as attorney for Mr. Trevino, is this also your signature on this document?
Yes, Your Honor.
And Mr. Villarreal, the Assistant Criminal District Attorney assigned to this case, is this your signature on this document?
Yes, Judge.
Okay. Everybody's on contract. They can't get away. And that's what I got. State, what did I miss?
Nothing, Judge. That's everything.
And Mr. Trevino, it says you were in the Navy. I can't punish you any worse than you already punished yourself. That was a joke, sir.
Well, I mean, I was a medic, so I was in the Marine Corps most of the time anyways.
Oh my goodness. Then you spent lots of time with known Marines. Did you go to the war?
Nothing exciting.
Okay. Appreciate your service, sir. Do you have any questions at this time?
No, Your Honor.
Mr. Moore is going to contact you, probably call you, give you a lot later today and get you set up to get read in on what's going on. All good?
Thank you, Your Honor.
All right. Thank you, Mr. Trevino. Thank you, Mr. Salazar. You're out
Thank
of
you,
here.
Judge.
Judge, may I give my spiel quick?
Sure, that'd be great.
All right. Anybody who is expecting to be placed on probation today, if you are residing, living outside of Bexar County or the state, or you intend on moving outside of Bexar County or the state, you need to let the judge know before you enter your plea. That way, in the case needs to be transferred, then you can be adjudicated properly and we can decide whether or not the case will be transferred. As for those of you being placed on probation today, you will receive a call or an email from the probation department probably within the next 72 hours. If when you wake up next Wednesday morning and you have not heard from the probation department, Ms. Benavides has put the telephone number that you need to call first thing Wednesday morning of next week and advise them that you need an orientation date. That telephone number is 210-335-7446. That phone number is in the chat. So if you haven't heard from probation by next Wednesday, when you wake up in the morning, 8 o'clock, then you need to call that number and tell them that you need an orientation date. Is there anyone here who currently resides outside of Bexar County or Texas or intends on moving? If so, speak up, please. All right.
I
Yes.
do, man. Actually, in about 7 months after I complete my my cybersecurity certifications, I'm going to be taking a job offer in Florida, in Tampa. So that I didn't know that I was supposed to let anybody know that because I wasn't sure just yet. But I was going to put it in with my current probation officer as the time got close.
Okay. Judge, at that time, he would not have enough time left to be transferred. So,
How many months would that be, Susan?
if he's granted now and he goes in, what'd you say, September?
Roughly, yes, ma'am.
Yeah, so he would be about a month short of being eligible for a transfer, but knowing how you are and how wonderful you are, if he has everything done and he has kept his halo on straight and shiny, you would possibly let him report by mail.
Mr. Rivera, that's the big deal of the day. get everything done before you go to Florida, and you can go to Florida, then you'll just be reporting either by Zoom or by mail. Fair enough?
Fair enough. Thank you. I appreciate that.
Good to go.
Okay, anybody else? Okay, that's all I got. Good luck, everyone. Thanks, Judge.
You bet.
Oh, excuse me, Your Honor.
Yes, sir. Go ahead.
I do have one question. Since I've been waiting for this court date, in the meantime, I've been taking outpatient treatment classes and doing AA/NA classes as well. Would that completion letter be able to utilized for anything that is going to be stipulated here?
Well, let me back up. Where are you taking outpatient drug classes?
I did it through the VA. I was authorized to do it through the VA.
Okay. How many classes have you gone to already?
I've already completed it. It was for 16. It was twice a week. Or yeah, 16. So twice a week for.
You know what they call it? They call that their basic outpatient drug course, or what do they call that course? Do you know out there?
I can't remember. I have a letter here, Your Honor.
I'm going to call it the VA outpatient drug course. Will that work?
Yes, sir.
If you bring us a completion certificate and present that to your probation officer, we'll give you credit for the outpatient drug course, and you won't have to take the basic CAT-SNP course. Okay.
You got it. Yes, sir.
All right.
The current probation officer has all that on file as well.
All right, great. Ms. Calderola, is that your understanding of the agreement?
Yes, it is, Your Honor. And also that it's going to run concurrent. Mr. Rivera is currently on probation, and it runs concurrent with 2018 CR 5707. And that's also running concurrent with cause number 618888. And this is going to run at the same time. That was our
Let
understanding.
me back up. The 2018 CR 5707, that's the correct number?
That is the correct number, Your Honor. It's out of the 144th,
What kind of case is that?
an assault. And he's been on deferred adjudication in that case.
And then what kind of case is 618888?
I believe it's a violation of a protective order.
And what court is that in?
That's out of 7, County Court 7.
Yeah, not a problem. We'll run them concurrent with both those.
All right, thank you, Your Honor.
Okay, let's make sure I get this right, guys. Mr. Rivera, on cause 651285, the court accepts your plea of no contest to the offense of driving while intoxicated with blood or breath alcohol content greater than 0.15. I find you guilty. I assess 1 year in the Bexar County Jail, probated for 18 months. A $600 fine plus court costs, 40 hours community service, DWI intervention, DWI victim impact panel. I'm going to assess the Community Alliance for Traffic Safety New Intervention Program, which is our basic outpatient drug alcohol course. However, if you provide proof that in the last year, I guess you have completed the Veterans Administration outpatient drug course, I'll give you credit for that, and you will not have to take the CAT-SNP course. Smart Start Mobile Home Interlock at 4 blows a day for half the term, which is 9 months. Defendant may move to Florida with the court's permission and the other 2 courts' permission, not just mine, in September, on or about September 22, as long as he's done everything he needs to do on this course, on his program so far, and he may report by mail or by Zoom, whatever the preference is of the CSCD department. This case will run concurrent with 2018 CR 5707 and 618888. Anything further from the state or the defense of Mr. Rivera?
Nothing from the state, Judge.
No, Your Honor, nothing more.
Slow down, Mr. Rivera. You're spending more time in court than the rest of us. That was a joke, sir. All right. Good luck, sir.
Thank you.
Thank you very much, Your Honor. May we be excused?
You bet. Thank you.
Thank you.
Okay, let's see what we're doing on Mr. Burnett. Mr. Burnett, in cause 674-777 to the charge of terroristic threat. How do you plead, sir? I guess it's terroristic threat causing fear. Does that sound right?
Not guilty.
Your Honor, I've informed him to plead no contest.
Yeah.
Okay. Mr. Burnett, to the cause of terroristic threat causing fear, my understanding is your attorney says you plead no contest. Is that correct?
Yes, sir.
Court accepts the plea of no contest to the offense of terroristic threat causing fear. Is there an agreement for Mr. Burnett and 674-777?
Yes, Judge. The agreement is for 16 months deferred adjudication, a $450 fine plus court costs, APSC course, and a no contact order with John Arthur Manuel.
Defense, who is John Arthur Manuel to Mr. Burnett?
just a bystander, I believe.
I mean, did they know each other, or at one time were they friends, any kind of relationship, or just they were strangers when all this went down?
I believe they were strangers when this all went down, Your Honor.
And is that correct, Mr. Burnett?
Yes.
All right, then you have no reason to see this person again, correct?
No, I don't.
All right, good answer, sir. And Mr. Herbst, is that your understanding of the agreement?
Yes, it is, Your Honor.
Mr. Burnett, in cause 674-777, the court accepts your plea of no contest to the offense of terrorist threat causing fear. Although I have enough evidence to find you guilty, I'm going to withhold a finding of guilt. Place you on 16 months, deferred adjudication probation, assess a $450 fine plus court cost, APSE course, or do you have no contact with John Arthur Manuel? Anything further from the state of the defense of Mr. Burnett?
Nothing from the state, Judge.
Your
And-
Honor, I have, Mr. Burnett has informed me that the Leon Valley Police Department has his chainsaw in inventory, and we would like some kind of documentation from the court that would authorize Leon Valley to release the chainsaw back to him.
What part did a chainsaw play in all this colorful activity?
Your Honor, if I may, the allegations were, the threats were made with the chainsaw.
Okay, but the chainsaw was never actually used on anybody, correct? I mean, we didn't like chop off an arm or something.
That's right, Judge.
Correct, Your Honor.
And this is Mr. Burnett's chainsaw, not somebody else's chainsaw.
Right, and he needs it for his tree service.
All right, get me an order, if you would, Mr. Herbst, and I'll release the chainsaw from Leon Valley PD back to Mr. Burnett. If he promises not to cut anybody up for a while. Is that okay, Mr. Burnett?
That's it.
All right, thanks.
Thank you.
Good luck, Mr. Burnett. Thank you, Mr. Herbst. Y'all are released.
May we be excused.
You bet.
Thank you, Judge.
Ms. Grimaldo, and cause 655-959. For the charge of driving while intoxicated with a blood or breath alcohol content of 0.15 or greater. How do you plead, ma'am?
No contest.
Okay. And Pat, once again, administratively, I need you to modify the defendant's waiver of constitutional rights and court's admonitions to reflect the crime of driving while intoxicated greater than 0.15 and not just driving while intoxicated. And
Yes, sir.
paperwork, Roland, the paperwork says guilty, but no contest is okay with me. If it's okay with the state, doesn't matter to us, I don't think.
That's okay, Judge. No objection.
You want to use no contest, Roland?
He's on mute.
Did we lose Roland?
Yes, Your Honor, that's fine.
All right. And also, Pat, we need to change guilty to no contest on the
I will, Your Honor.
waiver. Okay. And state, is there an agreement in this case?
Yes, Judge, it's for 12 months in the Bexar County Jail, probated for 12 months, a $600 fine, plus court costs, 48 hours of community service, DWI education, victim impact panel, Smart Start Mobile for half the term, and $60 to DPS for the lab.
I don't see the cat's nip course in here. What's going on with that?
That must have been left out by mistake, Judge. But yeah, I'm not seeing it on my end in the notes either.
Roland, I know how crafty and what a great lawyer you are, but we're going to need to input the cat's nip course. Any objection?
Oh, Your Honor.
All right, great. Thanks. And Mr. Garcia, is that your understanding of the agreement?
Yes, Your Honor.
Mr. Grimaldo, the court accepts your plea of no contest to the offense of driving while intoxicated with a blood or breath alcohol content greater than 0.15. I find you guilty. I assess 1 year in the Bexar County Jail, probated for 1 year, a $600 fine plus court costs, 48 hours community service, DWI education course, DWI victim impact panel, Community Alliance for Traffic Safety New Intervention Program, outpatient drug, Smart Start Mobile Home Interlock at 4 blows a day for half the term, which is 6 months. And $60 reimbursement to the Texas Department of Public Safety for lab fees. Anything further from the State or the defense on Ms. Grimaldo?
Nothing from the state, Judge.
Nothing from the defense, Your Honor.
How's your baby brother doing with his COVID situation, Roland?
More word gets around quick. He's doing just fine. He's sounding real good. I talked to him early this morning.
Telling me may want to call my personal physician, Dr. Cuervo. I think that'll kill it.
Okay.
All right. Good luck, guys. Y'all.
Thank you, Judge. Always a pleasure.
All righty. And let's see, we got Miss Moore going here. And State, you're not waiving the second enhancement. It stays a DWI second. Is that correct?
That's right, Judge.
Okay. Ms. Moore, on cause 654-902 to the charge of driving while intoxicated, second offense. How do you plead, ma'am?
Guilty.
Thank you. And Pat, once again, administratively, the offense on the defendant's waiver of constitutional rights form needs to say DWI second, not just DWI.
Yes, Your Honor.
An agreement for Ms. Moore, please.
Yes, Judge. It's for 12 months, Bexar County Jail, probated for 1 year, plus a $500 fine, court costs, $60 to DPS for the lab, 48 hours of community service, DWI intervention, victim impact panel, CATSNIT, and Smart Start Mobile for half the term.
And Mr. Hernandez, is that your understanding of the agreement?
It is, Your Honor. In regards to Smart Start Mobile, I believe that she was going to be asking to drive, so it'll be one of the two.
I'm confused. She can drive with a Smart Start Mobile.
Is it the mobile device that she's got the mobile device right now, the handheld one?
That's exactly. That's called a Smart Start Mobile, and it's called mobile because it's about the size of a big cell phone.
Yes, yes.
Go into it 4 times a day, so you can certainly drive with it, no problem.
Yeah, she just wanted to know whether or not she also has to have the ignition interlock.
No, if she has an ignition interlock, she's welcome to turn it in immediately when she gets active on the Smart Start, which obviously she already is, so she's good.
Okay, Judge. So if she's driving, she can drive with a Smart Start Mobile.
Sure.
Okay, that's fine. That's all we wanted to clarify.
As long as she has a driver's license.
She will or does, Judge.
Let's see if I get this
so that is the agreement, Judge, and then we would just like to address a couple other issues.
All right, go ahead right now.
Oh, okay, Judge. She has completed a 12-hour drug and alcohol awareness class and has a certificate. We would just ask the court to allow her to turn that into the probation department, and if it qualifies for any of the programs, that she get credit for that.
And where is that given?
This was through the, let's see. The course instructor was Robert A. Williams.
You say it was 12 hours?
It's a 12-hour program called North America Learning Institute.
I'll certainly give her credit for community service hours, 12 hours community service on it. I don't think it really equates to anything else we're doing.
That'll be fine.
That's fine.
Just whatever credit she can get. And then the second issue, Judge, if you recall, Ms. Moore has a number of rather serious medical conditions. She has lupus, she has osteoarthritis, she has heart problems. She's been in and out of the hospital and the emergency room throughout her pretrial stay. We have addressed a travel permit with her in the past, and the court allowed her to go to the Valley and also to Mexico to receive medical treatment, and to Corpus Christi, where she also receives treatment. She's asking the court for essentially an open travel permit, so that when she has either work, because she works in Corpus Christi, she is going to be working in Corpus Christi on and off as a provider, but she also receives medical treatment in Corpus Christi, also in the Valley, and also in Progreso. We would just ask the court to allow her to show proof of that information to probation and allow her to travel rather than just every single time she wants to or needs to go to the doctor that she has to get permission.
How often is she going to be going to doctors?
Judge, she's just in the last month, she's been probably 4 or 5 times locally to the ER and to doctor's appointments here.
How about out of Bear County? How many times in the last month?
She hasn't been going out of Bear County, Judge, because of pretrial. Pretrial's kind of reached the point where they don't want to deal, they didn't want to deal with her anymore because she has so many problems. Which is why we just decided to jump on the
and then
take care of the case.
Now let's back up about going to Corpus. Is she moving to Corpus and going to live in Corpus? What's going on in Corpus?
No, Judge. Prior to her getting sick about a year ago, she was working in Corpus, but living in San Antonio. It's 3 days on, 3 days off. She works for a company that provides home health to individuals down in the Corpus area. So that's where her job is, but she lives here in San Antonio. It's a 3 day on, 3 day off. She is trying to get back to work because she doesn't have any income and disability. It's taking quite a long time to address her.
Okay, here's the plan. If she needs to go somewhere for medical stuff outside of Bear County, she needs to get permission each time. And that doesn't sound like it's very often. I'm going to give her a blanket travel back and forth to Corpus for her work, as long as it doesn't interfere with any of the requirements of probation, okay?
That's fine. Thank you, Judge.
If she's active on her Smart Start mobile and she's current on everything, then that's not going to be a problem. Will that work for you guys?
Yes, sir.
It will, Judge. Thank you.
Okay, let's make sure I get this right then. Ms. Moir, on cause 654902, the court accepts your plea of guilty to the offense of driving while intoxicated. Second offense, I find you guilty. I assess 1 year in the Bear County Jail, probated for 1 year, $500 fine plus court costs, 48 hours community service, probating 12 of that, as long as you provide your graduation permit from the alcohol awareness 12-hour course. DWI intervention, DWI victim impact panel, Community Alliance for Traffic Safety New Intervention Program, outpatient drug, and Smart Start Mobile home interlock at 4 blows a day for half the term, which is 6 months. You're going to get a blanket travel permit back and forth to and from Corpus for work only. If you need to do something else, get permission. If you need out of Bear County medical services, we'll certainly give you permission. If it's an emergency, if you got something that your lawyer says, yes, that's an emergency, go, then your lawyer can call me after you've gone. I don't want you sitting at home having some sort of medical emergency and I'm waiting for me to make a ruling whether you can go somewhere. Okay. So if it's an emergency, you're cleared to go anytime, and just let your lawyer know and he'll let me know. Okay.
Yes, sir.
All right. And I believe that's all there is to it. What did I miss, Johnny?
Judge, there's an active warrant based on a pretrial violation.
We're going to recall all pretrial bond conditions and warrants. Okay.
That'll do it. Thank you, Judge. I believe that's it.
Good luck, Ms. Moore. Thank you, Tony.
Thank you, Judge.
Thank you. Have a good day.
You too. Okay. Mr. Peterson, let's see what we're doing with you. Mr. Peterson, in cause 643-249 to the charge of assault bodily injury. How do you plead, sir?
You're on mute, Mr. Peterson.
Can you hear me now, sir?
Yes, sir.
To the charge of assault bodily injury, how do you plead, sir?
No contest.
All right. Is there an agreement for Mr. Peterson?
Yes, Judge, it's for 12 months in the Bear County Jail, probated for 1 year.
No. I'm sorry, Judge. That's not correct. This was for a JSAT offer. This is the one that was decided by the felony court that we agreed on, and we set this for a plea for JSAT.
Let me check that real quick, Your Honor. Just 1 second.
No problem.
When we set it for a plea, we acknowledged that in front of everybody.
Ernie, what's your understanding of the plea bargain for a JSAT?
He has a certain number of days and he's on felony probation, and he did an additional 30 days house arrest recently. And so we had done email exchange with Laura Metzgold, and all this has been acknowledged in emails for the JSAT today. So I didn't think there'd be any issues.
The only thing that I have a question on is if there's restitution to the alleged victim, which of course is not going to be paid if there's a JSAT.
Yeah, I mean, there was not, Judge. It was a family barbecue kind of deal with a family friend. It was a light scuffle in the big scheme of things. And this was the agreement as part of a felony MTR. And Mr. Peterson is still on a felony probation. But this is how they decided to get rid of the misdemeanor case, and we agreed to it. with the felony disposition.
Eddie just needs to confirm it. And are you clear to go forward at this time, Eddie, or you need more time to talk to somebody?
I mean, Eddie, we've exchanged all those emails with Laura Metzgold, and you sent me an email saying like, yeah, that's all good. So I thought all this had been cleared up.
It may have. Let me just check my emails real quick. If you say I emailed you, it should be there.
Yeah, the E3 at Ernest Acevedo. I mean, yeah, like
Give me 1 second.
it's all been discussed.
Okay. Let's confirm JSAT deal. Yes, Your Honor, it is a JSAT deal.
All right. Do you know the terms of the JSAT at this time? Eddie, do you know like what the time of the my records show he has 2 days credit. So obviously he's got more credit on the felony or somewhere else that Ernie's talking about.
He did do 30 days house arrest on ELM as part of the MTR that included this case. And so he has that as well, Judge. And so I think a 32-day jail sentence for the credit for time served takes care of it.
How about I do what the sheriff does and make it 90 so it looks like we're really tough guys even though we're not?
As long as you say JSAT, Judge.
You're happy? All right, we're good. Eddie, what I request from the state is we make it 90 days, Bear County Jail, credit for time served, time and money to run concurrent, whatever fine amount you guys have agreed to. What's that going to be? Do we know?
What was that again, Your Honor? I'm sorry.
Okay, the sheriff gives 3-for-1 credit. So my perception of the law is I can allow 3-for-1 credit on sentencing also. So instead of saying 30 days for an assault, I'm going to say 90 days because even though he's only really done 30.
Right.
I'm going to say JSAT. He still gets the judgment satisfied out of it, and the defense doesn't object to that. And I'm just asking if the state objects to that because it's still JSAT. And
No
also,
objection, Your Honor.
I need to know what amount of fine that you guys have agreed to on this.
The fine I had was, the last fine that was sent was $450.
Is that okay with you, Ernie?
Yes, sir. As long as it's included for his time, there's no problem.
All right. Let's try this. Mr. Peterson, it costs 643-249. The court accepts your plea of no contest to the offense of assault bodily injury. I find you guilty. I assess 90 days in the Bear County Jail, a $450 fine plus court costs, credit for time served, time and money to run concurrent, judgment satisfied. Recall all pretrial bond issue or requirements, conditions, and any warrants that are still out there from pretrial, but apparently there aren't any, so we're good. So it's 90 days, 450, judgment satisfied. Anything further from the state or the defense on Mr. Peterson?
Nothing from the state, Judge.
Nothing from defense.
Good luck, Mr. Peterson. Thank you, Mr. Acevedo. Y'all are out of here.
Thank you, Judge.
And we can come off of YouTube, please.